XRP. Hinman got deposed. Was this just a distraction? Ripple is 1 foot in the grave. That was what the experts said after the U.S. Securities and Exchange Commission filed a lawsuit against the company behind XRP. But now it seems that the SEC has dug its own grave. Recently, Ripple named another small victory in the court that can lead to a big win. Magistrate Judge Sarah Netburn has ordered the deposition of William Hinman, former director of the United States Securities and Exchange Commission's Division of Corporation Finance, during a recent hearing. Now, if used properly, this deposition could be the key for Ripple to win the lawsuit. But it got delayed. There is something going on the backside, which we are unaware of. Hey guys, welcome back to Crypto Millionaires, a channel where we give daily updates about XRP. As we've announced a monthly giveaway of 1,000 XRP coins, so hit the like and subscribe button if you haven't already to participate in the giveaway. And don't forget to click the bell icon and share your views in the comments section below. Watch to the end for more chances to win the huge amount of your favorite coin. In today's video, we will talk about the recent victory of Ripple. We will discuss in full detail that what is the deposition about and why it got delayed. You will know about what the SEC is hiding and why they are afraid of Hinman's deposition. So, let's start our video. No one is unaware of the crypto trial of the century. The SEC sued Ripple co-founder Chris Larsen and Chief Executive Officer Bradley Garlinghouse in New York last year, saying they had created a vacuum that allowed them to sell XRP into a market with limited information they chose to share. The agency alleges that the two men personally profited by about $600 million and ignored legal advice that the cryptocurrency can be considered as an investment contract and therefore a security. It accused them of selling the virtual tokens without registering them as such. Bloomberg reports that Ripple has said the SEC can't regulate XRP because, as a virtual currency used in international and domestic transactions, it's a medium of exchange and not a security. Ripple had asked a U.S. magistrate judge to let it depose William H. Hinman, the former director of the SEC's Division of Corporation Finance, seeking testimony on the process the agency uses to arrive at policy decisions. The Securities and Exchange Commission had first filed a motion to quash Ripple's deposition subpoena directed to William H. Hinman, former director of the SEC's Division of Corporate Finance. According to the finance feed, the SEC argues that the defendant bear the burden of showing exceptional circumstances justifying the deposition and stated that Ripple Labs and its co-founders cannot meet this high burden. Now, Mr. Hinman was the one that ruled that Bitcoin and Ethereum are not securities, despite the latter debuting in an initial coin offering ICO in 2014. With XRP, they said its status had not been determined. When Ripple requested an internal documentation to explain how and why the SEC made its decisions, the regulator said that nothing Clayton and Hinman, as well as any SEC official, said about Bitcoin or Ether was an official determination on whether they are securities. However, according to the crypto law, an examination of the facts tells a very different story. For starters, Hinman is no longer a high-ranking government official. He is a private citizen. Surely after investing millions of dollars in Hinman while he was serving at the SEC, Simpson Thacher would give him adequate time off to answer some questions. The article on crypto law shared a really important piece of information. Before and after his tenure at the SEC, Hinman has been a partner at the law firm of Simpson & Thacher, which sits on the Enterprise Ethereum Alliance, a coalition of organizations devoted to the business case for the Ethereum blockchain. In 2018, Hinman declared offers and sales of Ether are not security transactions, in a speech that is still available on the SEC's website, sending its value soaring. Hinman received millions of payments from the firm while he was at the SEC, including when he prepared and delivered those remarks. If that was not a clear conflict of interest, then he needs to explain why under oath. According to the documented evidence, Hinman's personal financial interests were clearly connected to that speech he gave. Both Hinman and the SEC want us to believe that ETH speech should never have been interpreted as policy or any kind of notice about ETH's status, in the same way that the SEC argued in the Ripple complaint in December of 2020 that all of us should have known XRP was a security since 2013. It was a big deal to subpoena a former high-ranking official for a deposition in order to answer for actions while in office. Judge Netburn is not taking this question lightly. But when those actions were so clearly material to the central questions at dispute in the case as big and precedented setting as SEC vs. Ripple, it's a damn good reason to reject the SEC's attempt to shade Hinman and prevent the whole truth from coming to light. U.S. Magistrate Judge Sarah Netburn, after hearing on Thursday, ordered Hinman to sit for a deposition, saying that, as a high-ranking official who led one of the 6 divisions of the SEC, he held substantial authority in very important federal agency, as reported by Bloomberg. This is not a run-of-the-mill SEC enforcement case, Netburn said, adding that Hinman's deposition wouldn't open the floodgates. She said the case involves significant policy decisions in our markets. The amount in controversy is substantial, and the public's interest in this case is significant. Ripple's aim was partly to determine whether a June 2018 speech Hinman gave, saying that Bitcoin and Ether aren't securities, can be used to show the Commission's adaptation position and to develop evidence on whether market participants viewed XRP as a security. As per Ripple, Hinman's testimony will provide a critical window into the agency's communication with important third parties about regulatory status of cryptocurrencies. Now, this deposition can be the key for Ripple to win the lawsuit. Hinman had said that Ethereum is not a security, but we know that Ethereum and Ripple are not the same. According to the analysts, there is something going on, and it might have to do with the fact that he was paid by Ethereum. Even the Ethereum co-founder Vitalik Buterin has said that Ethereum is like XRP or Ripple. They call it the same, but at the same time, they say Ethereum is not a security, but Ripple is. Now, if Ripple comes up with good questions at the deposition, then we might get some new answers and surprises. The next thing that comes up is of when. Was this all a distraction? Because it was supposed to happen on Monday the 19th of July, but got delayed, according to AMB Crypto. The deposition of former Securities and Exchange Commission SEC Director of Corporate Finance, William Hinman, has been postponed to the 27th of July 2021. The same was earlier scheduled to take place on Monday, but both parties, that is Ripple and the SEC, plan to conduct an additional meet in the next few days to zero in on the issues related to Hinman's deposition. According to the letter sent to the U.S. Magistrate Judge Sarah Netburn, Ripple and the SEC agreed to postpone the said testimony after making substantial progress in narrowing and resolving the privilege issues. Attorney James K. Fillon provided the letter that the parties submitted to the court and noted Hinman's deposition postponed to July 27, 2021. The parties have made substantial progress in narrowing and resolving the privilege issues, and will continue to confer. Parties will report to the court on their progress on Monday by 5 p.m. As per the said document, at your direction, the parties met and conferred this morning on the privilege issues that arose during yesterday's hearing on the motion to quash the deposition of William Hinman. Based on this morning's discussions, we have agreed to adjourn the July 19, 2021 deposition of Mr. Hinman and have rescheduled the deposition for July 27, 2021. Ripple and the SEC will have to get back to the court by 5 p.m. on Monday to notify them about the status of their decisions and look into whether further judicial intervention was necessary. Hinman's testimony was originally scheduled for the 30th of June, but the SEC tried to quash it as explained earlier. As per the experts, it is very strange that the deposition was postponed because if a deposition is to happen, it happens on the expected date. It is never delayed or postponed. The reason for this delay can be that the SEC is afraid of what Hinman might say. Now we just have to wait and see what will happen. What questions will be asked and how will they be answered? Will this deposition prove to be good for Ripple? Only time will tell. According to the CoinMarketCap, at the time of writing, the XRP price today is 56 cents USD with a 24-hour trading volume of $1.7 billion USD. XRP is down 3.76% in the last 24 hours. The current CoinMarketCap ranking is number 6, with a live market cap of $26 billion USD. It has a circulating supply of 46 billion XRP coins and a max supply of 100 billion XRP coins. So guys, this is it for today's video. I hope it could be a big help to you. What do you think? Will this deposition lead Ripple to a win? Is Ripple near a major victory? Share your views in the comments down below. Don't forget to click the bell icon and participate in the giveaway. And thanks for watching.